Hello, everyone. Welcome to today's program at the Ethical Humanist Society of Chicago. I'm Kara Malenfant, and I'll be your moderator. Our platforms right now are virtual, given the COVID-19 concerns, and we really want to make sure to keep everyone safe and healthy. We aren't having our in-person gatherings anymore for the time being, but we really do look forward to the day when the time is right and we can resume our in-person gatherings. In order to help create a better understanding of who we are as a community and what we believe in, I'm going to read a short quote about humanism. The humanist lives as if this world were all and enough. He is not otherworldly. He holds that the time spent on the contemplation of a possible afterlife is time wasted. He fears no hell and seeks no heaven, save that which he and other men create on earth. He willingly accepts the world that exists on this side of the grave as the place for moral struggle and creative living. He seeks the life abundant for his neighbor as for himself. He is content to live one world at a time and let the next life, if such there may be, take care of itself. He need not deny immortality, simply is not interested. His interests are here. This quote is from Edwin Wilson, who is an American Unitarian leader and humanist who helped draft the Humanist Manifesto back in 1933. I thought it was especially appropriate not only to describe our community, but in light of today's talk. While you'll see that the chat box is open the entire time during this program, please know that we're going to have a good amount of time at the end of the presentation for questions and answers, so our speaker will address your questions then. Our programs address a wide variety of topics, including current events, philosophy, arts, and sciences, to name just a few. Today's presentation is Getting Your Affairs in Order, Estate Planning Essentials. People are feeling vulnerable and fearful in the midst of the pandemic. We can harness these emotions to take evidence-based steps to minimize risk. We can also write down our wishes for when we can't speak for ourselves. Svetlana Bekman will walk us through the basics of estate planning, including powers of attorney for property and healthcare, wills and trusts. Svetlana is a senior vice president and senior legal counsel at the Northern Trust Company, where she advises the bank on matters relating to trusts, estates, IRAs, and related fiduciary matters. Prior to joining the Northern Trust Company, Svetlana was a partner in the private clients group of Schiff Hardin, LLP. A fellow of the American College of Trust and Estate Counsel, Svetlana speaks and publishes articles and chapters on various aspects of IRAs and other retirement plans. She received her law degree from the Northwestern University School of Law and served as a clerk to the Honorable Elaine E. Buchloh, U.S. District Court of the Northern District of Illinois. Welcome, Svetlana.
Hi. Hi, everyone. Thanks, Kara. Thanks for the introduction. All right, yes, we will be speaking about estate planning today, and I thought that Kara's introduction and quote was very appropriate. So our agenda for today, I'll start with a disclaimer, as my employer requires. I will cover a lot of the issues that you may be interested in, but then, as you see from my last bullet point, what I don't cover, I'll be more than happy to address during Q&A, and I'll sort of hint at some of the things that I'm leaving off the main body of the presentation. So the disclaimer is that I am an attorney in the legal department of the Northern Trust Company. Prior to joining Northern, I was in private practice, and I actually worked with individuals on their estate plans. I no longer do that. My sole client is Northern Trust. And though I am an employee of Northern Trust, I'm not speaking as a representative of the organization. I'm just speaking as a private individual. And of course, these remarks are mine alone and also should not be treated as legal or tax advice. So as the introduction, or as the description of the program indicates, estate planning is simply writing down our wishes for when we can't speak for ourselves. And it's preparing for the what if, like buying insurance, for example. And the fundamental goal, I think, of estate planning is to give our loved ones a peace of mind that they know what it is that we want done regarding our person, regarding our health, regarding our finances, when we can no longer do so. And it really is, an exercise that many of us don't look forward to, but it's really about others in our life as much as ourselves. I think more so about those who will have to figure out what to do when we can't indicate what it is that we want to done. So the foundational concepts that I'm going to talk about cover sort of two temporal dimensions. There is what happens during life if a person is disabled. And then, of course, there's also the disposition of assets after death. And so we will start with durable powers of attorney. So the first thing is that, generally speaking, a power of attorney is a legal document where you name someone to undertake actions that you can't undertake for yourself. What you want is for the power, it's very important that this document or that this power of attorney be durable, which means that it is effective even after your disability. The person who executes the power of attorney is referred to as the principal. The person whom you name or whom the principal names as agent or power of attorney, different terminology is used. That's the person to whom you're giving this authority. The rules, this is a very kind of a state-specific document. And so the rules will vary state by state in terms of the execution requirements and what an agent can and can't do. I will focus on Illinois, since I assume that most of you attending are Illinois residents. And on this slide, I'm giving you a website that houses both the healthcare power of attorney and a property power of attorney for Illinois. And very user-friendly. You can print it out, you can fill it out. And later, I'll actually be speaking about preparing estate planning documents, but certainly this is a place where you can find powers of attorney that are valid and easily completed. So in particular, let's speak about the healthcare power of attorney. There's some other terminology that you may hear: healthcare proxy, advanced directive, medical care directive. So your agent named under this document can make various healthcare decisions for you, such as the kinds of tests that would be performed, medications that you would be given, surgery, and any other type of really medical intervention, including life support and nutrition and hydration. I mean, something like being put on a ventilator that we've all unfortunately become rather familiar with over the pandemic. That's the kind of thing that an agent under the healthcare power of attorney may be called upon to decide yay or nay. Under Illinois law, in order to have a validly executed power of attorney for healthcare, it must be signed by you and witnessed by at least one person who is not also named as agent. And as I say, you can find a copy of the power in that website. Typically, whom would you select to be your agent here? A family member or a friend? It's very important that you obviously ask them whether they're willing to perform these responsibilities for you, and also discuss with them your particular philosophy about using extraordinary measures for prolonging life, so that if the time were to come, they would know what it is that you would want to do if you were able to speak for yourself. And by the way, I should note that if your medical provider is able to communicate with you at all, right? If they're able to elicit a response from you and get your informed consent to whatever is the medical intervention, that's what they're going to do. They're only going to look to your agent. The medical provider will only look to your agent if indeed you are so severely incapacitated, basically in a coma, that you are just not able to communicate, or sedated or something like that, right? So it's not as if the agent can override your wishes. Your wishes, if at all ascertainable by the physician in the moment, will control. And your agent will only step in when the physician simply is not able to communicate with you. All right. The next power of attorney is the durable power of attorney for property. Again, you can find the form on that website over there. Here, the agent is able to handle your various property and financial affairs, such as pay bills, sign income tax returns or other kinds of tax returns, buy, sell investments, buy, sell your home, what have you. Now, the difference between a power of attorney for property and power of attorney for healthcare is that the power of attorney for property becomes effective, unless you provide otherwise, when you sign it. So theoretically, you give the authority to this agent even while you're perfectly competent, and theoretically, the agent could, sell the proverbial house from under you. Now, yes, abuses of that sort do happen, rarely. The important thing is that whomever you choose to be your agent has to obviously be someone who is trustworthy and who will understand that you only want them to act in the event that you're not able. We can talk a little bit more about that. There is a concept of a springing durable power of attorney for property, where the agent does not obtain authority to act until you have been determined disabled, but there are issues with that. So typically, you name someone today, they have the ability to act today, but of course they understand and you trust that they're not going to go ahead and, sell your house from under you. Okay, so that's the temporal dimension of while you're living but not able to act for yourself. And now we're going to move into the territory of disposition of assets after death. And most presentations begin with a will or trust. But based on my personal experience and based on, experience of a lot of other people, often the kinds of assets that we own actually are not transferable by will, but rather are transferable by beneficiary designation. So many of us have retirement accounts, 401k, 403b, IRA, individual retirement account, Roth IRA, and such. So those retirement accounts are not transferred via a will. They're transferred via a beneficiary designation. Life insurance is another example of that type of asset. So what it simply means, and I know you've all experienced it, is that the provider of the custodian of this particular property will give you a form, and in that form you indicate who your primary beneficiary is, or beneficiaries, right? You can leave your 401k to your children equally, for example. And in addition, there is also a section called contingent beneficiary or secondary beneficiary, and that refers to the taker who would step in the event that the primary beneficiary dies before you do. So there's not much to say about beneficiary designations. You have really complete freedom as to whom you designate with respect to retirement accounts and insurance, except that 401k plans are subject to federal law, and federal law says that if you are married, then your spouse will be the default taker the inheritor of the 401k. And if you want to leave the 401k to someone else, the spouse has to waive their right to the plan. So this is one facet of a disposition of a 401k that is not completely within your control. Now, what happens if you have an asset such as this and you do not complete a beneficiary designation form? The documents that govern life insurance, retirement plans have within them what are called default beneficiary designations. So if you leave those boxes blank for whatever reason, then what happens is the default provision in the governing document will tell us what happens to the life insurance, what happens to the 401k after you pass away. And typically it's, whom you would expect. The default is spouse if living, otherwise descendants if living, otherwise your estate. So that's the beneficiary designation. So the next type of disposition that I want to talk about, which again, many of us have or would be subject to, and again, this is not something that a will would control, and that is form of ownership. And in particular, I'm referring to joint tenancy with rights of survivorship. You may have heard of that. Some of you may own bank accounts and certainly real estate. And so here again, the will does not control the way in which the asset passes. If a son and a mother, for example, own a bank account, a savings account, let's say, in joint tenancy with rights of survivorship, when mom dies, the son becomes the sole owner. And it doesn't matter what mom may or may not say in her will, the operation of law, that's the term of art, the operation of law tells us what happens to the asset. Another very common form of ownership for residential real estate for married couples is called tenancy by the entireties. So again, this is the kind of ownership where if, say, my husband Mike and I, we own our home in tenancy by the entireties, which means that if I die first, Mike owns the house in full. Again, it doesn't matter what I may try to do in my will or my trust, the house passes to Mike. And furthermore, during life, neither one of us can sell the house without the consent of the other. So that's an aspect of tenancy by the entireties that's different than joint tenancy with rights of survivorship, where one tenant, one owner actually can transmit or even deplete that bank account that I described to you earlier. So that's tenancy by the entireties. And finally, there's another type of joint tenancy. So this is called tenancy in common. So you might think of three siblings owning a vacation home that their parents previously owned. And this is the kind of property that often will be owned by people who are not spouses. And what it means to own, let's say, a vacation home as tenants in common is that each tenant, each owner, has the right to use the entire property, but also if that tenant were to die, let's say we've got the three siblings, the 1/3 does not get absorbed by the other two surviving siblings. That 1/3 of that vacation home actually is transferable by the tenant to, say, their children. So that's tenancy in common, which does not have the survivorship aspect in it. So as I'm going through these various assets, you might be thinking to yourself, oh, I've got the 401k, I got the life insurance, I got my house, I got my vacation condo, whatever, right? And you can be beginning to think about whether you have designated who the next owner will be, right? And if you haven't, you might think about what that next owner should be, right? So far, not a lot of room for legal advice, professional advice. I think this is all fairly straightforward. But then we get to a will, because there are certain assets which are not transferable by beneficiary designation or by operation of law. And those you will need a will for, and there are other purposes to have a will. So, generally, again, it's the legal document where you outline your wishes for assets that are not disposable in the two manners that I earlier described. You also can you would name an executor or personal representative who will be in charge of your estate, and I will talk about that in a little bit. If your estate is large enough and there are estate taxes to be paid either at federal or state levels, then that's where you would provide a clause that tells the executor how those expenses should be taken care of. And very importantly, if you are a parent of minor children, a will is where you express your wishes, where you designate who it is or who the individuals may be that you would want to act as guardians of the minor children. So if there are two parents, whether they're custodial parents or whether they're divorced and the kids are living with one or the other, but as long as there is at least one parent still living, that parent would step in upon the death of the first one. So you don't need to worry about designating a guardian in the event that just you pass away and your ex-spouse or current spouse is still living. It's in the event that there is neither parent, or in the event that there is only the one parent. If that person or those persons are gone, then this is where you want to say that your wish is that so-and-so be the guardian of your minor children. Now, this is only an expression of a wish on your part. A court would still have to appoint your chosen person or persons as guardians or guardian. But, it's rare that a court would not respect the deceased parent's desires. I mean, somebody would have to come into court, object, raise reasons why the designated individual is not suitable as a guardian. So it really is important to indicate whom you want to act, because if you don't, then you do put your survivors in a position of having to figure out who's going to take care of the kids. They'll still have to go to court, right? But what if there's conflict? Or what if people are not prepared for the responsibility? When you name someone in your will, you, of course, first discuss with them that this is something you want to do, and discuss with them how it is that you envision that they would raise your kids. It's a difficult conversation to have, to be sure, but an important one. So I have laid out in this little example some, it's just off the top of my head, provisions that a will might contain, and I will actually come back to them in a little bit. I want to now tell you what happens if you don't have a will. So let's suppose that you do not have a will and also have assets that do not pass by operation of law or by beneficiary designation. Then what will control will be state law. So with respect to these assets that, you didn't specify your wishes for, right? You didn't say, I want to give this to so-and-so and I want to give that to so-and-so. Then we will look to intestacy law in Illinois. We will look to Illinois law. And what Illinois law tells us is that, well, let me give you an example. Suppose that I don't have a will and I have assets that don't pass by beneficiary designation or operation of law. My estate will pass 1/2 to my surviving spouse, 1/4 to one of my sons, and another quarter to another of my sons. That's what the law tells us. If I have no spouse, my children will take equally. If I have no children, my spouse will take the entire thing. If I have neither a spouse nor children, then parents and siblings. Sort of, the law basically does kind of the logical thing. It as we say in the profession, it selects the natural objects or it designates the natural objects of a person's bounty, and it says you will take. And in many instances, right, the law of intestacy or intestate succession would mirror what you would otherwise provide in your will. But then again, in my case, if I pass away, I would like Mike to have all my largesse, and my kids can wait to get it after he dies, right? So in my case, for example, I wouldn't want my kids to get half of my stuff, such as it is. I would want Mike to get it all. And so for that, I would need a will, because the law of intestacy would not mirror my actual intentions. So let's imagine that you do have a will or you don't have a will. You pass away and there is property that needs to be transmitted, and the legal process by which that's going to happen is called probate. Probate is where your executor, let's say you have a will, right? So your executor, and what I think I'm going to do is I'm going to scroll back to my will and I'm going to illustrate to you what it is that the executor is going to have to do as a function of probate. So the executor goes to court, files papers, a petition. Well, the first thing actually the executor would do is file the will with the court. And this is something that that you want to be aware of, because a will is a public document. So it must be filed with the court upon a person's death, and whatever is in it is available for the public who is interested or curious. And so you might think about whether you have privacy concerns such that you would want to avoid your will or your wishes becoming public. And we can talk about that probably more during Q&A. Anyway, the will is filed with the court. Then your executor shows up in court and says, I am petitioning for what are called letters of office. Letters of office are, literally these documents that the court issues to the executor. And these letters of office authorize the executor now to deal with the decedent's property in the same way that the decedent would have been able to deal with it. So, for example, I leave my primary residence to my husband if he survives me. Let's suppose that I own my primary residence not in tenancy by the entireties, but I just own our house, right? So I have told the executor that the executor needs to create a new deed. And in that deed, the new owner will be Mike Dupuis, and my executor will complete that deed, sign that deed, and then record that deed with the Cook County's office, records office, whatever. Anyway, so that's the way in which my executor will implement my wishes and transfer the ownership of this house from me to my husband. I do not own a boat, but if I did, I could possibly leave it to one of my children. And again, my executor with that letter of office would be able to complete a document whose legal effect would be to change title on the boat from Svetlana Bekman to Daniel Dupuis. And then I also leave $100,000 to my parents who survive me in equal shares. So my executor will have to take some assets that are in my estate. Let's say I have investment accounts. The executor will sell at least $100,000 worth of those investment accounts, right? So the executor will have to transact with Vanguard, and Vanguard will have to take direction from my executor as to my investment account. And then the executor will write a check for $50,000 to my dad and $50,000 to my mom. And then I leave the residue of my estate to the Ethical Humanist Society of Chicago. So my executor will then liquidate really all of my assets, not the house, because I've given that to Mike, not my boat, because I've given that to Daniel. $100,000 goes to my folks. And now the balance, this big old check, is written to the Ethical Humanist Society of Chicago. So this is what my executor will do. And now my estate is empty. My executor has implemented my wishes. If I am wealthy enough and I owe estate tax, my executor will complete and sign an estate tax return. My executor will certainly complete and sign an income tax return that I would have done had I survived a particular tax year. And then the executor will go to court and say, I have done my job. Please, court, release me. And the court will issue a document saying that the executor's duties are completed, the executor is released, and the estate is closed. So that's what an executor would do. Sorry, let me get my notes back online here. Okay, we talked about intestacy. We talked about what an executor would do. You're probably thinking, whom do I want to name as executor? And most people just kind of automatically name their surviving spouse or their children. That's fine. I tell you, I helped my husband administer his mother's very modest estate. And even though, I'm a professional, I know this stuff, it was a pain. I really should have just hired an attorney. So tell your executor that especially if they're not a professional, whether a lawyer, an accountant, or an investment professional, even if they are, right, they have a full-time job, presumably they have other things to do, they should feel free at the expense of the estate to hire a professional to help them do all this. Or you could name, I suppose if your estate is large enough, you could name an institution like the Northern Trust Company, and by no means am I trying to sell our services, but there are people who do estate administration for a living, whose job it is, like estate planning attorneys who are in private practice. So just think about whether the person that you're naming is willing and able to do this work. And if they are willing and able, tell them that they ought to hire whatever kind of helpers that they may need in order to get this done. The cost of that help will come off the top off the top of the estate, and then the balance will be distributed as I provided in my sample will. All right, so now the question is, do I do this myself, this being my estate plan, or do I hire a lawyer? So I would say that when it comes to something like powers of attorney for healthcare and property, you can totally do those yourselves. I mean, if you click on the websites that I provided and you read through the introductory information, which is taken right out of the actual statute that creates those concepts, you'll see that it's pretty jargon-free, that it's comprehensible by a layperson. It's just really not rocket science. So if all you're thinking about is I want somebody to make healthcare decisions for me when I can't, and I want someone to, pay my bills and sign my tax returns, I think you can probably do your own powers of attorney for healthcare and property. When it comes to a will or a trust, that gets a little bit trickier. And really the reason that it's tricky is because if this is not something you're really expert in, right, you don't know what you don't know. And so it's just hard to know if you're missing something. Now, what would you do if you wanted to do it yourself? There are now several providers, online providers. I guess I'll call them robo estate planners, just like robo investors, right? You can do that. There are various companies that offer do-it-yourself investing, but they also utilize an algorithm that would sort of point you in the right direction. So I have not used robo estate planners myself. I created a will for me and Mike like eons ago, and that will, is the thing that's going to operate. So I don't know how to use one of those, but from what I understand, such providers as Rocket Lawyer, LegalZoom, Free Will, Quicken, Willmaker, and Trust 2020, and another one called Trust and Will, all of those utilize some sort of an algorithm, right, whereby they kind of interview you, ask you various relevant questions, and then generate a will or a trust, as well as, by the way, powers of attorney for property and healthcare. They generate those documents on the basis of your answers to those questions. And then you print them out, and then you execute them. I mentioned that a power of attorney for property, actually, maybe I didn't. That one has to be notarized and witnessed. The power of attorney for healthcare only needs to be witnessed, and a will in Illinois requires at least 2 witnesses, doesn't have to be notarized. And every state is going to have its own execution requirements for all of these documents, and wills in particular. It's important to observe the specific execution requirements for these documents so that they're actually valid. So these robo estate planners will ask you questions. You'll generate the documents, you'll print them out, you'll execute them, and it might be enough. I mean, I'm thinking if you're motivated enough, right, to do this on your own, you're going to go online, you're going to read all of the various introductory materials, and you're probably going to get a sense, sort of a gut feel as to whether this is something you want to do yourself or not. If you're feeling uncertain, then you'll ask your CPA or your investment professional, or sometimes employers will have a list of providers that they could share with you, right? And you'll tab those resources and you'll ask for a recommendation, and then you'll go and you'll meet with an actual live human being. Maybe you'll Zoom with them, I don't know, these days, and they will prepare your will or your trust or your powers of attorney. But if you feel like, what, I'm reading through this stuff, I'm understanding it, my assets that are not transmissible by beneficiary designation or operation of law are not that many, and I got my spouse or I got my kids, it's not rocket science, I can do a will using one of these robo estate planners. So I would just trust your gut, I think, in this case. I would say that if you have a lot of money, if your estate is substantial, maybe that's an instance where you'll want to get professional advice. If you are in a, let's say, second marriage, and let's say your spouse has children from a prior relationship and you have children from a prior relationship, that's probably the kind of factual scenario where you would want to consult with a provider or consult with a professional. If you have a disabled child who needs, let's say, a special needs trust. So there are certain factual scenarios where probably even these robo-advisors would steer you away from a do-it-yourself and steer you towards a professional. And what I discovered when poking around a little bit on these robo-advisors, some of them offer a hybrid approach. So for a little bit more, I don't really know what the fees are, but for some extra, right, an extra fee, you can gain access to a stable of their attorneys whom you can ask questions. And that might just be the ideal scenario for many, many people, is to do your own will and then, or trust, and then have access to a professional who can, I don't know, review it, answer some questions. So it's a tough one. If you read online, if you Google, should I do my own will, you will almost certainly come upon attorneys describing horror stories that they have experienced or that their colleagues have experienced trying to untangle a do-it-yourself mess, right? And their recommendation is going to be, don't do it yourself. Absolutely, get advice from a professional. Well, they're biased, right? These robo estate planners are their competition. And also the sample, the data that the attorney is dealing with is very limited, right? They don't know of the, I don't know, hundreds, thousands perhaps of simple wills that got administered with no problem. What they know about and what they focus on are the horror stories. So again, there is the fact that, yes, you could mess it up, but then there's also the fact that you'll probably figure out whether you're up to the task. There's also the hybrid that I described to you that's definitely worth exploring. On the other hand, maybe if you don't know what you don't know, speaking to a professional and telling them, this is my family situation, these are my objectives, that professional is immediately going to know what questions to ask based on your particular situation, right? Because they've done many of these plans. So I'm sorry that I don't have a straightforward yay or nay, but hopefully I've given you some of the issues that you'll want to be thinking about as you embark on this process. So I am done rather early, but there are a lot of other issues that we can talk about. Some of them that I didn't cover, but would be happy to address during Q&A are living trusts, state taxes, remote execution of documents, which is particularly relevant these days, and anything else that you might want to ask me about. So I thank you for your attention, and I look forward to answering questions.
Thanks to all of you for thinking of some good questions. I can tell they're rolling in. So I'm going to go ahead and read the questions one by one, and then Svetlana will answer them. And hopefully we'll get to all of them, but if not, we'll have some informal time for continued conversation and coffee hour. So Svetlana, is there anything specific you could tell viewers who would be preparing a will for parents who travel together in the event that both parents of a child perish? Is there anything different than you already gave us in terms of the advice about preparing wills?
Yeah, something that is often included in a will or a trust is what should be the presumption in the event that the order of deaths can't be determined, right? So a will might say, a will of a mother might say, I leave my estate, let's say, to my husband if he survives me. And the husband presumably will say the same thing. I leave my estate to my wife if she survives me. If two people are traveling together and perish in a common accident, you sort of get into this, well, it's not possible to determine who survived whom. And so what you will then provide in the will, what generally a drafts person will provide in a will, is that if the order of deaths cannot be readily ascertained, then I shall be deemed to have survived my spouse, or my spouse shall be deemed to have survived me. And you will want to have something different in the other will or trust, and that way you don't get into this sort of infinite loop. Other than that, a will always say, I, wife, leave it all to my husband if he survives me, but if he does not, I leave it ... So in the event that the other partner does not survive, a well-drafted will almost certainly provide what happens in the event that the first person who's chosen does not survive, if that makes sense.
Great. Another question. If one dies intestate, is there a way for a bank account of the deceased to pay for burial expenses?
Sure. So what happens if one dies intestate? Two things could happen. In Illinois and many other jurisdictions, there is an abbreviated administration process that does not require an executor. It's called a small estate affidavit. So if a decedent's assets are less than $100,000, and I am speaking about assets that are not transmissible by beneficiary designation or operation of law, and they are 100,000 or less, then a child, a parent, a friend, a surviving spouse can complete what's called an affidavit. And in that affidavit, they will attest to various things, including the fact that the estate is less than 100,000, and that document will serve as a substitute for what I described to you as the letters of office. Then this person, with that small estate affidavit, will go to the bank and say, I am the rightful successor owner of this bank account. The bank will transfer the bank account into the name of this individual in their fiduciary capacity, and then out of that account, that individual will pay the expenses that you are describing. So the bank is not going to be involved in the payment. Rather, the person who has completed the small estate affidavit will act as a substitute executor. Now, if the estate is larger than 100,000, then somebody, notwithstanding that there's no will and no one designated as executor, someone is going to have to go to court and get appointed as executor. So a probate is going to have to be opened, even if there is no will, for an estate that's in excess of 100,000. That individual will receive the letters of office, will go to the bank, will get the account, and pay the expenses. So that's how that's going to play out.
If one wants to dictate how the remains are to be handled, what is that? Does that need to be written down in a will? Is there some other similar document? Right. How would you explain that?
Thank you for that. That's another place where a will is the place where you would say those things. I'm not aware of any other documents where this can be indicated. I do know that a power of attorney for healthcare in Illinois, you can, in that document, you can authorize your agent after your death to donate your organs. And there may be other provisions. Off the top of my head, I'm not sure if in that document you can provide for such things as cremation or no cremation, right? I do know about the donation of organs, and you can do that outside of a will. But if you want to say something about, I want this kind of a memorial service or not this kind of a memorial service, I want cremation, I don't want cremation, I want my ashes scattered, all of that, I believe, can only be indicated in a will. I'm not 100% sure. But certainly in a will. Whether there's a substitute for a will, I don't know. But yes, definitely a will.
Great. And we have another question about wills. What's the most common thing people overlook when thinking through what to call out in their wills? Like, is it pets or sentimental objects, or is there some other thing among their estate that they just forget to include and forget to call out?
So again, in my experience at the bank, where I don't actually, advise clients, but I see our estate administrators administering estates, sometimes the conflict in the family arises over things of nominal financial value, but very substantial sentimental value. So especially in the case of a second death, if there are objects that the children are going to potentially fight and disagree over, it would behoove the person who's planning, right, and the person who's writing down their wishes to say that I leave my jewelry or maybe a specific ring to so-and-so, and I leave my stamp collection to so-and-so. Because I have seen suddenly, death of a parent, especially of a survivor, can sometimes bring out long buried conflicts among the children. It's a stressful time, it's a tragic time, and then, mom liked you better than me. So if mom can possibly avoid that by saying, you get this and you get that, now there might still be hard feelings, but at least there's no question as to who gets the stamp collection, who gets the jewelry, who gets the chair, who gets the photo album. I would say those are the things that are worth thinking about.
Great. Can you say more about the way to defer the initiation of the property power of attorney?
Yes. So if you look at, I don't have a copy in front of me, but in the power of attorney for property, you can check one of several boxes, or maybe one of two boxes. One box is this power of attorney becomes effective immediately upon execution. And by the way, if you don't check that box and you check no box, then that's when the power of attorney for property becomes effective. The second box is something to the effect of this becomes effective, the power of attorney for property becomes effective upon my disability. So at first glance, it looks helpful, right? But the question is, what does that mean upon my disability, right? Let's say somebody is in a car accident, and the agent takes the power of attorney. The person is in a car accident. They're not able to speak for themselves. So they're in a coma. And the agent needs to go to the bank and get some cash to pay expenses, let's say, right? So they take the power of attorney, they bring it to the bank, they show it to the bank, and the bank says, oh, I see it says if the individual is disabled, can you please show me evidence that the individual is disabled, right? The bank doesn't want to transact with the agent because the bank has liability if they do something wrong. They're seeing that the precondition for the legal effectiveness of this document is that the principal, right, be disabled. The agent says, my dad was in a car accident. He's at the hospital. He's in a coma. Well, bring me the documents to that effect. So that doesn't seem all that complicated, right? You go to the hospital, you get a note from a doctor, but what if the person isn't in a car accident, but they're declining cognitively, right? What if the determination of disability isn't so simple as getting a note from a doctor? What if you need to get a note from their physician who's been treating them that says, yeah, I'm treating them and they're suffering from Alzheimer's such that they don't know, they're not able to make their own decisions. So I guess what I'm pointing out is that there is an additional step or two that will have to be taken if you condition the effectiveness of the agent's authority on your disability. And, it might not be a big deal, right? In the first instance. In the second instance, the doctor is going to have to be willing to sign that note. Is the doctor going to be reluctant to sign that note, depending on the circumstances, right? Might be, right? So that's what I'm suggesting. I'm suggesting, and most estate planners will tell you, if you can't trust the person to not sell the proverbial house from under you, you shouldn't be naming them as agent. And if you trust them, name them as agent. They will be agent on day one, but they won't actually exercise that authority until you are truly disabled in any kind of sense of the word.
Thanks. That's a super helpful designation. And that example in particular really brought it home for me. Another person asks, what are the main reasons to have a trust? And in particular, what role does tax minimization play?
Okay, so the kind of trust that I think you're referring to is called a living trust or a revocable trust. So this is a trust that you would create today, and you would retain the right to both amend it in any and every way and also revoke it entirely as long as you are competent and living. And the reason that you would do this in addition to a will, and you wouldn't do it instead of a will, you would do it in addition to a will. And I'll say a little bit more about it in a minute, but the reason you would want to do it is not for tax minimization as much as for three reasons. One is privacy, one is avoidance of probate, and the third is better disability planning, you might say, than just having a power of attorney for property. So a living trust or a revocable trust is a document where you're going to be the trustee of this document or of this trust. And so for practical purposes, you're going to operate just the same as you did before you created a trust. But what you will do is you will take the assets that are not subject to beneficiary designation or operation of law, and you would fund the trust, which means you would transfer the ownership of those assets from yourself into the trust. And so when the dust settles, Svetlana Bekman, as trustee of the Svetlana Bekman Revocable Trust, owns, I don't know, my house. If I owned it individually rather than in tenancy by the entireties, it would own my house. It would own my investment account. It would own my bank account. And so going forward, if I were writing a check, I would sign a check not as Svetlana Bekman, but Svetlana Bekman as trustee of the Svetlana Bekman Trust. So as I say, for practical purposes, the way that you're still able to deal with your property is unchanged. The income tax consequences are unchanged. But if you become disabled, and here are the three reasons why this is a useful exercise. If you become disabled, in the document, in the trust document, you provided, in the event that I'm disabled, I shall cease to act as trustee, and I name as successor trustee, fill in the blank. You become disabled, your successor trustee steps in, and they're now able to manage all of the assets that you previously transferred into the trust on your behalf. So it's very much like a power of attorney for property, but there's a higher level of fiduciary responsibility that is placed on a trustee than is placed on an agent under a power of attorney. And if you have a lot of assets, that's probably a way to go. So that's disability planning. Privacy is your trust will not be filed with a court when you pass away. So if you do a trust, you will also have a will that will not say, I give this to so-and-so, this to so-and-so, this to so-and-so. It will say, I give my estate to the trustee of my revocable trust, period. That document will be filed with a court, and there's really no information contained in that public document. Your trust has all of the various provisions about how you want your property disposed of, and that is a private document. So that's privacy. Avoidance of probate. The reason you avoid probate is because the trust is not, the trustee does not have to go to court and say, court, give me letters of office so I can now start selling the various assets in the trust and dispersing them as pursuant to the terms of the trust. The trustee has that authority. So you don't have to go to court to get the permission to, in my little example over here, let me just go back to here. So if I had transferred my residence to my trust will say, I leave my primary residence to my husband. My executor, my trustee, does not have to go to court and ask permission to retitle the primary residence. It's in the document. There is no further legal process that has to happen in the court. I leave my boat. Well, a boat, usually you wouldn't transfer to a trust. So essentially, you minimize the amount of interaction that you would have to have in a court trying to dispose of your estate. All of the provisions are in the trust, and those do not require permission from a court. And as to the minimization of taxes, that can be done just as easily in a trust as in a will. I will tell you that currently the exemption per person from federal estate tax is $10 million adjusted for inflation. And I will tell you what it actually is. It is $11,580,000. So if you have, so basically, regardless of whether you leave that amount of assets or less under a will or a trust, this amount is not going to be subject to the estate tax at the federal level. At the state level in Illinois, the exemption is $4 million. So there will be Illinois estate tax due unless you do certain planning. But I would say that the planning can be done within a will or within a trust. The vehicle doesn't really matter. You minimize taxes by giving property away during life, or by leaving property to spouses and charities. Property left to spouses does not incur estate tax at the first death. Property left to charity never incurs estate tax. So there are various things you would do during life and at death in order to minimize or defer estate tax. But, you have to be pretty well-to-do, certainly to be subject to the federal estate tax, and, reasonably well-to-do to be subject to the Illinois estate tax. And by the way, for married couples, right, you double that amount. So a married couple under federal law has an exemption of $22 million and change. Under Illinois law, exemption of $8 million.
Thanks. One question I'll ask, but you can decide whether you want to take it or you feel like you've covered it enough. I think you might have more to say about giving us an overview of revocable trusts. Who, what, where, when, why?
Right. Yeah. So I think I talked about the living trust, also known as the revocable trust. So that's where, and maybe I should have included it as part of my the body of my presentation, but this is where you created for reasons of maintaining privacy after you die, because a trust is not subject to, it's not a public record that you file with a court. It's also a somewhat better disability planning mechanism, especially if you have substantial assets. And thirdly, it reduces the amount of probate that has to happen. And, a lot of people say, oh my God, probate. In Illinois, it's fairly straightforward. I described to you kind of what probate would involve. So, there's really no downside to having a trust except transaction costs, right? You would have to pay someone to prepare it for you, or you'd have to do it yourself. And then the critical thing is you actually have to fund it. In order for the thing to work in the three ways that I described, in order for the thing to actually give you the three advantages, you have to actually retitle, as we say, assets from your individual name to your trust name. And I remember when I was in private practice, people would spend all kinds of money preparing these beautiful estate plans, and then they just wouldn't move the assets. And so the trust can't really do what it's supposed to do unless you move the assets. And what you may find if you're considering a living trust or a revocable trust is that most of your assets aren't really subject to transfer to a trust during your life. For example, life insurance. Well, I shouldn't say you can't. You can transfer ownership of a life insurance to a living trust, but you really don't get any benefit from that. You certainly can't transfer your retirement accounts. Those of us who are married tend to own our real estate in tenancy by the entireties, and I'm not sure how much benefit there is to changing that, unless, of course, you don't want, maybe the property is yours. You may be married, but you don't jointly own the property, in which case you could pop the house into the living trust. This is, I think, where you would want to consult with an attorney, because an attorney would be able to look at the inventory of your assets and would actually identify the assets that would be transferable to a living trust. And on the basis of that, you might say, you know what, my $50,000 investment account at Vanguard, I don't really need a trust just so that I can house that asset in that trust. I mean, that would be, hopefully that makes sense.
So one sort of related follow-up, which I think I might be able to answer based on what you just said. So a trust, is it the case then that a trust cannot be listed as a beneficiary of a retirement account? You couldn't.
Actually, it can be. It can be. It often is. So I guess the distinction, very legal distinction, is between who owns the thing, right, and who will get it after you die. You can name your trust as beneficiary. And this is where the thing about retirement accounts is that they enjoy certain kind of favored income tax status while you're living, and also your beneficiaries do after you pass away. And sometimes, often, naming a trust as beneficiary tends to reduce those income tax benefits. So that's actually an area of my expertise. I'm guffawing about it only because it is really. I can go really, really deep into the weeds on naming trusts as beneficiaries of retirement accounts. This is, again, where you'd want to get, I think, professional advice or do a lot of research.
Great. Switching gears away from trusts and back towards wills, could you talk about registering a will once it's produced? Do you need to register it in the county of residence?
You don't. I'm not aware of wills having to be registered anywhere. Certainly not in Illinois, and I'm not aware of any jurisdiction where that's required. I want to just, if you don't mind, go back to the question about naming a trust as beneficiary. So what I'm guessing, where the question might be coming from, is a young parent or a young couple, or a couple with young children, right? And they're doing estate planning, and their kids are minors, right? And they're imagining that both of them would perish in a common accident. And here's their 401k or their 401ks, and they want the kids to have the benefit of these assets, right? But they don't want to name the kids outright because the kids are minors. What I think the questioner may be thinking about is, well, shouldn't I create trusts for my children until they are 18, 25, 35, 50? I have some clients, or the bank has some clients, where there are trusts for life for people, right? So in that case, yes, if you're trying to provide for the eventuality where your children are orphaned and they're still minors, it does make sense to have trusts for them. And in that case, it would make sense to channel all of your various assets, including life insurance, including 401ks and everything else, into trusts for these minor kids. So I think I spoke too quickly, but I'm glad I caught myself.
Well, I think there might be some follow-up conversation on that one in the coffee hour. It seems like there's people are interested in that. At least one person is.
Okay.
All right, here's a totally different and kind of fun question. When you were in private practice, what was the most absurd request you had to implement or be prepared to implement after someone passed?
We had a client who wanted to be cryogenically, who wanted to be frozen and wanted to create a trust that would own his frozen remains or his frozen body, right? I mean, the idea would be to get frozen upon your death so that when medical science in, some futuristic scenario advanced to a point where they could cure the particular disease that killed this individual, that they would be defrosted and resurrected. So there was a very, very wealthy client who wanted a trust that whose terms would govern his eventual defrosting. I didn't end up drafting that trust. I don't think that we actually accepted that engagement, because how in the world do you do such a thing? But I think that was the most absurd, at least to me, request.
Yes, very far out there. How could you? So so many questions you would have to even ask. You couldn't even think of all of them. Okay, here's one more question. I've worked with small estate affidavits, usually done after someone is deceased. Is that something that can be done or prepared before someone passes away?
I don't think so, because a small estate affidavit asks questions that can only be answered at the time after the decedent passed away, because, for instance, it asks you to affirm in Illinois that the estate is less than 100,000. Now, and also it needs to be dated. You say such things as so-and-so died on such and such a day in the county of such, right? Obviously not something that is known before the fact. The amount of the estate, I'm trying to think what else. Those are the only two things that pop into my mind. You can Google small estate affidavit in Illinois, and you can see the kinds of questions that are being asked that I don't think you can you can't answer. And also you have to identify yourself, I think, as heir, if I'm not mistaken. Of course, there might not be an heir, but in any event, I think they're specific to the to the time after death, and that they're not ever prepared in advance.
All right. Please go ahead, folks. If you have more questions, type them in chat. If not, I'll go ahead and follow back up with some of the chat that I saw around designating a trust as a beneficiary. There was some questions about that. So here we go. I thought designating trust as beneficiary on retirement assets simplified estate disposition upon death.
Well, so yes, in one way it simplifies disposition in that if you think about having various different assets, let's say you have a home, life insurance, and a 401k, rather than saying in the beneficiary designation that you leave it, let's see. So I guess naming a trust as beneficiary allows you to consolidate all of your assets, whether they be insurance and or retirement accounts, in one place. And so in that way, I guess it simplifies it, right? Let's suppose that you have a variety of people that you want to benefit. Let's say you want to benefit your siblings, your friends, and then you want to leave a big chunk to the Ethical Humanist Society, rather than providing all of that in the beneficiary designation of your 401k, saying I leave 100,000 over here and 200 over here, and please see attachment. You include all of that in a trust, and you name the trust as beneficiary. So yes, I guess that's a way to simplify it by channeling all of your assets into this one bucket, and in this one bucket, having a long litany of how you want to, whom you want to benefit and how you want to benefit them.
And we always like to close our programs with a quote. And so I tried to think of one that talked about the future and being ready for what may come. And I saw this Malay Proverbs and thought it was appropriate. Prepare the umbrella before it rains. Thanks. See you in coffee hour.